The judgment in SOM v. Kreidel is reversed. Notes and questions. 1. The basic law. Today almost all states impose a duty to mitigate on residential landlords. The rule also applies to commercial tenancies in many states. The restatement, 2nd, of Property 12.1.3, however, continues to cling to the common law notion that a landlord can wait until the end of the term and then sue the tenant for all of the unpaid rent. The authors of the restatement believe the traditional rule discourages abandonment, limits vandalism, and better protects the expectations of landlords. 2. Tenants still on the hook. Importantly, the duty to mitigate does not relieve an abandoning tenant of all liability. Even if a new tenant rents the unit, the Property 254. Landlord can still recover damages for all of the costs of finding the replacement tenant and for any time that the unit remained empty. The landlord can also recoup any unpaid rent that accrued before the abandonment. Finally, if the rental market in the area has softened and landlord is forced to rent the unit at lower price, the tenant is responsible for the difference between the new rent and the original rent. 3. Property v. Contract. The lingering controversy over the duty to mitigate stems largely from the property/contract tension inherent in the nature of the lease. If a leasehold is primarily a property interest, then the landlord has few responsibilities to the tenant after ceding possession and control. The tenant is free to use the property or let it lay fallow. If, on the other hand, the lease is viewed through the lens of contract law, the parties clearly have a responsibility to mitigate damages. But see Edward Chase and E. Hunter Taylor, Jr., Landlord and Tenant, A Study in Property and Contract, 30 Vil. L. Rev. 571, 1985, arguing the distinction is overstated. 4. What's a good faith effort? Ken rents an apartment to Sarah for 1 year. 3 months into the lease, Sarah gets a new job in a different state and turns the apartment back over to Ken. Ken puts an 8x11 for rent sign in the window of the unit. Has he made a good faith effort to mitigate damages? Does it matter how he advertises the other units? What if Tim offers to rent Sarah's unit but Tim has bad credit? Does Ken have to accept Tim? 5. The legend of Jim Kreidel. The woman Jim Kreidel intended to marry came from a family with significant assets. When the engagement fell through, Kreidel, who had no income of his own, could not afford the rent at the Pierre apartments. The opinion mentions that Kreidel notified SOMA of his predicament in writing, but does not reflect that Kreidel and SOMA also had a heated discussion on the phone. During the telephone conversation, Kreidel offered SOMA $750 of the prepaid rent as compensation for breaking the lease. Adjusted for inflation, that's roughly equivalent to $3,000 today. SOMA, however, knew that Kreidel's stepfather was a prominent, and presumably well-off, physician and demanded an additional $750. Kreidel refused, and told SOMA, if you don't like it, you can sue me, baby. SOMA did just that. Chapter 8, Leasing Real Property 255. When the litigation began, Kreidel was a first-year law student at Rutgers. He initially represented himself but gradually picked up pro bono help from lawyers he met at summer jobs and partners in the firm where he worked after graduating. Kreidel estimates that SOMA, a very wealthy landlord, spent over $500,000 on legal fees. Kreidel also recalls that the law of New Jersey was firmly against his position that the lease should be governed by contract principles. On appeal, he relied primarily on a case from the state of Oregon, which opposing counsel disparaged as a place full of bumpkin fishermen and loggers. When Kreidel won, he wrapped the opinion around an Oregon salmon and sent to SOMA's lawyers. Asked why he pursued the case with such vigor, he replied, SOMA was wrong. The rule was unfair. And I was probably the only tenant in New Jersey who could afford to pour that much time and attention into a case like that. In the intervening years, Kreidel has had a long and successful legal career in New Jersey and New York. He's currently best known for representing Real Housewives of New Jersey star Teresa Giudice in her bankruptcy proceeding. 5. Tenant exit, eviction. If a tenant fails to pay rent or otherwise commits a material breach of the lease, the landlord can elect to terminate the leasehold and evict the tenant from the property. It is undoubtedly true that the eviction process and the subsequent scramble for a new place to live can be a traumatic, humiliating, and disruptive occurrence. Eviction displaces children from their schools, rends the social networks of the poor, and forces many families into shelters or onto the streets. Matthew Desmond, a sociologist at Harvard, has found that forced relocations are also shockingly common. In Milwaukee, the location of Desmond's research, 17% of the moves undertaken by renters over a 2-year period were forced relocations. See Matthew Desmond et al., Forced Relocation and Residential Instability Among Urban Renters, 89 SOC. SCI. Rev 227, 2015. In response to the social cost of eviction, some American cities and many countries around the world make it difficult for landlords to remove tenants. Should more U.S. jurisdictions follow suit? Consider the following story. Property 256. A patient political scientist might be able to place American cities on a left to right spectrum according to how long tenants whose eviction has become a cause manage to stay where they are. It may be, for instance, that some city like Houston is on the far right of the spectrum. Houston's most powerful citizens are known for a devotion to private property so intense that they see routine planning and zoning as acts of naked confiscation. San Francisco might qualify for the left end of the spectrum. IT's best-known evictees are the tenants of the rundown 3-story building called the International Hotel. In the fall of 1968, about 150 people who were living in the hotel were told to be out of the building by the 1st of January 1969. The building was finally cleared, in what amounted to a military operation requiring several hundred policemen, on the 4th of August 1977. Calvin Trillin, Some Thoughts on the International Hotel Controversy, New Yorker, the 19th of December 1977, at 116. Notes and questions. 1. Would you rather be a tenant in a place like Houston, where evictions happen quickly, or in San Francisco, where they do not? 2. Imagine you're a landlord in a jurisdiction where it takes a long time to remove a tenant for non-payment of rent. How would that change your business strategy? Would you ever take a chance on a tenant with bad credit or a history of being evicted? We turn now to the procedure of eviction. When a landlord believes that a tenant has committed a material breach of the lease, how exactly does she go about removing a lessee from the property? Bird v. Wiley. 264 N.W.2D 145, Min 1978. Rogoshisk, Justice. Defendant Landlord, Wiley Enterprises, Inc., and Defendant Rodney Wiley, hereafter collectively referred to as Wiley, appeal from a judgment upon a jury verdict awarding Chapter 8, Leasing Real Property 257. Plaintiff Tenant, a Family Affair Restaurant, Inc., damages for wrongful eviction from its leased premises. The issues for review are whether the evidence was sufficient to support the jury's finding that the tenant did not abandon or surrender the premises, and whether the trial court erred in finding Wiley's reentry forcible and wrongful as a matter of law. We hold that the jury's verdict is supported by sufficient evidence and that the trial court's determination of unlawful entry was correct as a matter of law, and affirm the judgment. On the 11th of November 1970, Wiley, as lessor, executed a written lease agreement letting land and a building in Osseo, Minnesota, for use as a restaurant. The lease provided a 5-year term beginning the 1st of December 1970, and specified that the tenant agreed to bear all costs of repairs and remodeling, to make no changes in the building structure, without prior written authorization from Huili, and to operate the restaurant in a lawful and prudent manner. Huili also reserved the right at his option to retake possession of the premises, had the lessee fail to meet the conditions of this lease. 1. In early 1971, plaintiff Kathleen Berg took assignment of the lease from the prior lessee, and on the 1st of May 1971, she opened a family affair restaurant on the premises. In January 1973, Berg incorporated the restaurant and assigned her interest in the lease to a family affair restaurant, Inc. As sole shareholder of the corporation, she alone continued to act for the tenant. The present dispute has arisen out of Huili's objection to Berg's continued remodeling of the restaurant without procuring written permission and her consequent operation of the restaurant in a state of disrepair with alleged health code violations. Strained relations between the parties came to a head in June and July 1973. In a letter dated the 29th of June 1973, Huili's attorney charged Berg with having breached lease items 5 and 6. by making changes in the building structure without written authorization and by operating an unclean kitchen in violation of health regulations. The letter demanded that a list of 8 remodeling items be completed within 2 weeks from the date of the letter, by Friday, the 13th of July 1973, or Huili would retake possession of the premises under lease item 7. Also, at the 13th of June inspection of the restaurant by the Minnesota Department of Health had produced an order that certain listed changes be completed within specified time limits in order to comply with the health code. The major items on the inspector's list, similar to those listed by Huili's attorney, were to be completed by July 15, 1973. Property 258. During the 2-week deadline set by both Huili and the health department, Berg continued to operate the restaurant without closing to complete the required items of remodeling. The evidence is in dispute as to whether she intended to permanently close the restaurant and vacate the premises at the end of the 2 weeks or simply close for about 1 month in order to remodel to comply with the health code. At the close of business on Friday, the 13th of July 1973, the last day of the 2-week period, Berg dismissed her employees, closed the restaurant, and placed a sign in the window saying closed for remodeling. Earlier that day, Berg testified, Huili came to the premises in her absence and attempted to change the locks. When she returned and asserted her right to continue in possession, he complied with her request to leave the locks unchanged. Berg also testified that at about 9:30 p.m. that evening, while she and 4 of her friends were in the restaurant, she observed Huili hanging from the awning peering into the window. Shortly thereafter, she heard Huili pounding on the back door, demanding admittance. Berg called the county sheriff to come and preserve order. Huili testified that he observed Berg and a group of her friends in the restaurant removing paneling from a wall. Allegedly fearing destruction of his property, Huili called the city police, who, with the sheriff, mediated an agreement between the parties to preserve the status quo until each could consult with legal counsel on Monday, July 16, 1973. Huili testified that his then attorney advised him to take possession of the premises and lock the tenant out. Accompanied by a police officer and a locksmith, Huili entered the premises in Berg's absence and without her knowledge on Monday, July 16, 1973, and changed the locks. Later in the day, Berg found herself locked out. The lease term was not due to expire until the 1st of December, 1975. The premises were relet to another tenant on or about the 1st of August, 1973. Berg brought this damage action against Huili for intentional infliction of emotional distress and other tort damages based upon claims in wrongful eviction. Huili answered with an affirmative defense of abandonment and surrender and counterclaimed for damage to the premises. With respect to the wrongful eviction claim, the trial court found as a matter of law that Huili did in fact lock the tenant out, and that the lockout was wrongful. The jury, by answers to the questions submitted, found no liability on Berg's claim for intentional infliction of emotional distress and no liability on Huili's counterclaim for damages to the premises, but awarded Berg $31,000 for lost profits and $3,540 for loss. Chapter 8, Leasing Real Property 259. Of chattels resulting from the wrongful lockout. The jury also specifically found that Berg neither abandoned nor surrendered the premises. On this appeal, Huili seeks an outright reversal of the damages award for wrongful eviction, claiming insufficient evidence to support the jury's finding of no abandonment or surrender and claiming error in the trial court's finding of wrongful eviction as a matter of law. The first issue before us concerns the sufficiency of evidence to support the jury's finding that Berg had not abandoned or surrendered the leasehold before being locked out by Huili. Viewing the evidence to support the jury's special verdict in the light most favorable to Berg, as we hold it amply supports the jury's finding of no abandonment or surrender of the premises. While the evidence bearing upon Berg's intent was strongly contradictory, the jury could reasonably have concluded, based on Berg's testimony and supporting circumstantial evidence, that she intended to retain possession, closing temporarily to remodel. Thus, the lockout cannot be excused on ground that Berg abandoned or surrendered the leasehold. The second and more difficult issue is whether Huili's self-help repossession of the premises by locking out Berg was correctly held wrongful as a matter of law. Minnesota has historically followed the common law rule that a landlord may rightfully use self-help to retake leased premises from a tenant in possession without incurring liability for wrongful eviction provided two conditions are met. 1. The landlord is legally entitled to possession, such as where a tenant holds over after the lease term or where a tenant breaches a lease containing a reentry clause, and 2. The landlord's means of reentry are peaceable. Mersel v. Brulette, 69 NW 218, 1896. Under the common law rule, a tenant who is evicted by his landlord may recover damages for wrongful eviction where the landlord either had no right to possession or where the means used to remove the tenant were forcible, or both. See, e.g., Poppen v. Wadley, 51 N.W.2D 75. 1952. Huili contends that Berg had breached the provisions of the lease, thereby entitling Huili, under the terms of the lease, to retake possession, and that his repossession by changing the locks in Berg's absence was accomplished in a peaceful manner. In a memorandum accompanying the post-trial order, the trial court stated two grounds for Property 260. Finding the lockout wrongful as a matter of law. 1. It was not accomplished in a peaceable manner and therefore could not be justified under the common law rule, and 2. Any self-help reentry against a tenant in possession is wrongful under the growing modern doctrine that a landlord must always resort to the judicial process to enforce his statutory remedy against a tenant wrongfully in possession. Whether Berg had in fact breached the lease and whether Huili was hence entitled to possession was not judicially determined. In applying the common law rule, we have not before had occasion to decide what means of self-help used to dispossess a tenant in his absence will constitute a non-peaceable entry, giving a right to damages without regard to who holds the legal right to possession. Huili argues that only actual or threatened violence used against a tenant should give rise to damages where the landlord had the right to possession. We cannot agree. It has long been the policy of our law to discourage landlords from taking the law into their own hands, and our decisions and statutory law have looked with disfavor upon any use of self-help to dispossess a tenant in circumstances which are likely to result in breaches of the peace. We gave early recognition to this policy in Lobdell v. Keene, 88. NW 426, 430, 1901, where we said, the object and purpose of the legislature in the enactment of the forcible entry and unlawful detainer statute was to prevent those claiming a right of entry or possession of lands from redressing their own wrongs by entering into possession in a violent and forcible manner. All such acts tend to a breach of the peace, and encourage high-handed oppression. The law does not permit the owner of land, be his title ever so good, to be the judge of his own rights with respect to a possession adversely held, but puts him to his remedy under the statutes. To facilitate a resort to judicial process, the legislature has provided a summary procedure in Min. Street 566.02 to 566.17 whereby a landlord may recover possession of leased premises upon proper notice and showing in court in as little as 3 to 10 days. As we recognized in Mutual Trust Life INS. Company v. Berg, 246 NW 9, 10, 1932, t. He forcible entry and unlawful detainer statutes were intended to prevent parties from taking the Chapter 8, leasing real property 261 law into their own hands when going into possession of lands and tenements. To further discourage self-help, our legislature has provided treble damages for forcible evictions, SS 557.08 and 557.09, and has provided additional criminal penalties for intentional and unlawful exclusion of a tenant. 504.25. In Sweeney v. Mayers, Supra, we allowed a business tenant not only damages for lost profits but also punitive damages against a landlord who, like Wiley, entered in the tenant's absence and locked the tenant out. In the present case, as in Sweeney, the tenant was in possession, claiming a right to continue in possession adverse to the landlord's claim of breach of the lease, and had neither abandoned nor surrendered the premises. Wiley, well aware that Berg was asserting her right to possession, retook possession in her absence by picking the locks and locking her out. The record shows a history of vigorous dispute and keen animosity between the parties. Upon this record, we can only conclude that the singular reason why actual violence did not erupt at the moment of Wiley's changing of the locks was Berg's absence and her subsequent self-restraint and resort to judicial process. Upon these facts, we cannot find Wiley's means of reentry peaceable under the common law rule. Our long-standing policy to discourage self-help which tends to cause a breach of the peace compels us to disapprove the means used to dispossess Berg. To approve this lockout, as urged by Wiley, merely because in Berg's absence no actual violence erupted while the locks were being changed, would be to encourage all future tenants, in order to protect their possession, to be vigilant and thereby set the stage for the very kind of public disturbance which it must be our policy to discourage. We recognize that the growing modern trend departs completely from the common law rule to hold that self-help is never available to dispossess a tenant who is in possession and has not abandoned or voluntarily surrendered the premises. Annotation 6A.L.R.3D 177, 186, 76 Dickinson L. Revelation 215, 227. This growing rule is founded on the recognition that the potential for violent breach of peace inheres in any situation where a landlord attempts by his own means to remove a tenant who is claiming possession adversely to the landlord. Courts adopting the rule reason that there is no cause to sanction such potentially disruptive self-help where adequate and speedy means are provided for removing a tenant peacefully through judicial process. At least 16 states have adopted this modern rule, holding that judicial proceedings, including Property 262, the summary procedures provided in those states' unlawful detainer statutes, are the exclusive remedy by which a landlord may remove a tenant claiming possession. While we would be compelled to disapprove the lockout of Berg in her absence under the common law rule as stated, we approve the trial court's reasoning and adopt as preferable the modern view represented by the cited cases. To make clear our departure from the common law rule for the benefit of future landlords and tenants, we hold that, subsequent to our decision in this case, the only lawful means to dispossess a tenant who has not abandoned nor voluntarily surrendered but who claims possession adversely to a landlord's claim of breach of a written lease is by resort to judicial process. We find that Min. Street 566.02 to 566.17 provide the landlord with an adequate remedy for regaining possession in every such case. where speedier action than provided in 566.02 to 566.17 seems necessary because of threatened destruction of the property or other exigent circumstances, a temporary restraining order under Rule 65, Rules of Civil Procedure, and Law Enforcement Protection are available to the landlord. Considered together, these statutory and judicial remedies provide a complete answer to the landlord. In our modern society, with the availability of prompt and sufficient legal remedies as described, there is no place and no need for self-help against a tenant in claimed lawful possession of leased premises. Applying our holding to the facts of this case, we conclude, as did the trial court, that because Wiley failed to resort to judicial remedies against Berg's holding possession adversely to Wiley's claim of breach of the lease, his lockout of Berg was wrongful as a matter of law. The rule we adopt in this decision is fairly applied against Wiley, for it is clear that, applying the older common law rule to the facts and circumstances peculiar to this case, we would be compelled to find the lockout non-peaceable for the reasons previously stated. The jury found that the lockout caused Berg damage and, as between Berg and Wiley, equity dictates that Wiley, who himself performed the act causing the damage, must bear the loss. Affirmed. Notes and questions. 1. Who did what wrong? Kathleen Berg, the tenant, never missed a rent payment. Why, exactly, did Wiley think he was entitled to enter the property and exclude the tenant? Is Rodney Wiley at fault for this dispute? If you were his lawyer at Chapter 8, Leasing Real Property 263. The time, would you have given him different advice? If he was entitled to possession, how did he end up owing $34,500 to Berg? 2. Tending to cause a breach of the peace. In case you aren't convinced that repossession carries an inherent risk of a breach of the peace, consider the story of Erskine G. Bryce. In the summer of 2001, Mr. Bryce, a 66-year-old city marshal in Brooklyn, New York, arrived at the second-story apartment of 53-year-old Joanne Jones to remove her from possession pursuant to a duly issued court order for her eviction. At the time, Miss Jones owed about $14,000 in back rent. She violently attacked the marshal, knocking him over a stairwell railing down to the ground floor below. Mr. Bryce's head hit a refrigerator on the way down. Miss Jones grabbed an aluminum rod, ran down the stairs, and began beating Mr. Bryce with the rod. She then doused his body with paint thinner and set him on fire with a cigarette lighter, almost as quickly as it had arisen. Miss Jones's rage subsided, and she attempted to put out the flames she had ignited by running back and forth to her apartment to fetch basins of water. But it was too late. The medical examiner concluded that Mr. Bryce died from a combination of blunt force injuries and the flames that quickly consumed his upper body, in other words, that he had been beaten to within an inch of his life and then burned alive. C.J. Chivas, tenant held in murder of Marshall, N.Y. Times, the 23rd of August, 2001. 3. Mr. Bryce had 2 decades of experience as a marshal and a reputation for dealing calmly and compassionately with those he evicted. He was a stranger to Miss Jones until he arrived to evict her. But in the moment, the situation still exploded into horrific, deadly violence. How much more likely do we think such violence would be where a landlord, who has a personal stake in recovering possession, no particular professional experience in managing or diffusing tense situations, no imprimatur of government authority, and a bitter history with the tenant, attempts to repossess. 4. Do landlords love violence? If the court here is correct that all self-help remedies contain the inherent potential for violence, why do landlords seem so eager to employ them? Why would a landlord ever resist going through the court process, which the Justice Rogowczyk describes as adequate and speedy? Property 264. 5. Can landlords stand their ground? Many states have so-called stand your ground laws. Stand your ground laws authorize individuals to use deadly force In self-defense when faced with a reasonable threat, there is no duty to retreat. First, why are legislatures concerned about violence in the landlord/tenant context but not in the self-defense setting? 6. Costs. Who does the demise of self-help hurt? 7. Basic eviction procedure. Every state has now enacted statutes, often referred to as forcible entry and detainer laws, that help landlords to promptly regain possession when a tenant holds over or commits a material breach of the lease. In most jurisdictions, statutes mandate that landlords pursue relief through the court system and refrain from self-help remedies. While these eviction procedures vary between jurisdictions, there are some significant commonalities between most states' forced entry and detainer laws. In all jurisdictions, for example, a landlord who wishes to evict a tenant must first send the tenant proper written notice. The notice requirement generally obliges the landlord to accurately state the tenant's name and address, and reveal the nature of the alleged breach. Most states also require the landlord to give the tenant an opportunity, often 3 days, but sometimes as long as 14, to either cure the default or move out. These are often referred to as cure or quit notices. If the tenant corrects the problem, they must be allowed to stay. However, if the tenant stays in the unit and does not cure the default, the landlord can file a petition for eviction with the local housing court. Upon the landlord's request, the court will quickly set a trial date and a process server will deliver a summons and complaint to each tenant. Most tenants do not contest their evictions. If the tenant does not respond to the summons, the court will enter a judgment in favor of the landlord and the landlord will then hire a local sheriff to remove the tenant from the property. The entire process generally takes from 20 to 60 days. 8. Defending against eviction. Occasionally a tenant will mount a vigorous defense to an eviction notice. The most commonly raised defenses are: 1. Notice was faulty, 2. The tenant cured the default, 3. The landlord illegally. Chapter 8, Leasing Real Property 265. Retaliated against the tenant, and 4. The tenant had a right to withhold rent because the unit failed to meet certain minimum standards required by law. 6. Tenant exit, security deposits. Most landlords require their tenants to pay a security deposit, a sum of money that the landlord can raid if the tenant defaults on the rent, leaves the unit untidy, or damages any property during the course of the tenancy. State law mandates that if the tenant has complied with all terms of the lease and kept the unit in good order, the landlord must return the security deposit, generally within 30 or 60 days. If the tenant causes damage, the landlord has the right to use the security to restore the unit to its previous condition, but must provide the tenant with a list of damages and receipts for the repairs. Although the law of security deposits is generally crystal clear, a huge number of renters report that they have unfairly lost deposit money to their landlords. Why is this so? Game theorists argue that the structure of the landlord-tenant relationship makes disputes over security deposits almost unavoidable. The key insight is that while the tenancy is ongoing, landlords and tenants have incentives to get along and make compromises. The landlord wants the tenant to make timely rent payments and the tenant wants the landlord to respond quickly when problems arise. However, once the landlord and tenant decide to end their relationship, there are few checks to prevent bad behavior. If the landlord will never interact with the tenant again, why not fudge a little bit with security deposit? Additionally, the small amounts of money involved. Security deposit disputes mean that it's rarely worth hiring a lawyer or taking the time to sue the landlord in small claims court. Notes and questions. 1. Tenant self-help. If tenants recognize that landlords often cheat them out of their security deposits, why don't more tenants respond by refusing to pay the last month's rent? After all, eviction procedures almost always take longer than 30 days. 2. America v. England. To solve the security deposit dilemma, English law does not permit landlords to keep their tenants' deposits. Rather, they must place Property 266 them with a government-approved holding agency. If a dispute arises over the money at the end of the lease, the parties are referred to an arbitrator who works for the organization that holds the money. The Dispute Resolution Service does not charge either party, but they are bound by its decision. Should jurisdictions in the US move toward this model, would it change your opinion to know that English landlords routinely fail to comply with these rules? Are there other solutions worth considering? D. The quest for clean, safe, and affordable premises. In feudal England, policymakers and government officials expressed little concern over the housing conditions of renters. The law was well settled: once a landlord turned over the right of possession, the tenant became responsible for maintenance of the leased property. If a tenant decided to live in squalor rather than complete basic repairs, that was the tenant's problem, not the landlord's worry. Although it may seem counterintuitive to modern readers, who rely on landlords to fix nearly everything, putting the burden on the tenant to maintain the property actually produced efficient results. In the medieval world, landlords often lived long distances from their lessees. Communication was slow, houses were simply constructed, and most tenants had the knowledge and skills to complete basic repairs. The basic principle that tenants are responsible for their own living conditions remained unchallenged until the 1960s, when both academics and politicians expressed growing concern about the rental housing stock in central cities. Many worried that exploitative landlords were flouting safety regulations and taking advantage of tenants who had few housing choices as a result of their poverty and the rampant discrimination in the housing market. The problems in the poorest neighborhoods also had spillover effects in surrounding communities. Disease, vermin, and fires do not respect municipal borders. In response to these problems, the law began to vest tenants with a new series of rights against their landlords. This subsection traces the evolution of these rights and explores the rise of legal tools to ensure minimum housing standards for all renters. Chapter 8, Leasing Real Property 267. 1. The Covenant of Quiet Enjoyment. Traditional common law principles do not leave renters completely defenseless against unprincipled landlords. Every lease, whether residential or commercial, contains a covenant of quiet enjoyment. Often this promise is explicitly stated in the lease contract. Where it's not specifically mentioned, all courts will imply it into the agreement. The basic idea is that the landlord cannot interfere with the tenant's use of the property. Most courts state the legal test this way: a breach of the covenant of quiet enjoyment occurs when the landlord substantially interferes with the tenant's use or enjoyment of the premises. Consider the following hypothetical. Little Bo Peep Detective Services rents the second floor of a 4-floor building. A year into the 5-year lease, the landlord suddenly begins a construction project designed to update the suites on the first floor. These renovations create loud noise and regular interruptions of electric service. The construction work has also made the parking lot inaccessible. Employees and customers need to walk a quarter-mile to access the building from a nearby parking garage. Do these problems amount to a violation of the covenant of quiet enjoyment? 2. Determine whether the interference is substantial. Courts generally consider the purpose the premises are leased for, the foreseeability of the problem, the potential duration, and the degree of harm. In this example, if the construction project lasts for more than a few days, then Little Bo Peep can most likely bring a successful claim against its landlord under the covenant of quiet enjoyment. The problems here are not mere trifles. The noise, lack of electricity, and inadequate parking fundamentally affect the company's ability to use the property as they intended. The difficult conceptual issue with the covenant of quiet enjoyment concerns the remedy. If the landlord breaks the covenant, what are the tenant's options? After a breach, the tenant can always choose to stay in the leased property, continue to pay rent, and sue the landlord for damages. Property 268. Additionally, certain violations of the covenant of quiet enjoyment allow the tenant to consider the lease terminated, leave, and stop paying rent. Recall from earlier in the chapter that the landlord's fundamental responsibility is to provide the tenant with possession, or, in some jurisdictions, the right to possession. From that principle, courts developed a rule that in cases where the landlord wrongfully evicts the tenant, all the tenant's obligations under the lease cease. Imagine. Landlord and tenant both sign a lease that reads, landlord agrees to provide tenant with possession of 123 Meadowlark Lane for a period of 12 months. Beginning April 1st. Tenant agrees to pay $100 per month. After 4 months, however, the landlord retakes possession of the property by forcing the tenant out and changing the locks. Assuming the tenant hasn't committed a material breach, the landlord's actions constitute an obvious violation of the covenant of quiet enjoyment. The tenant can no longer use the property for any purpose. Thus, any eviction where the tenant is physically denied access to the unit ends the tenant's obligation to pay rent and allows the tenant to sue for damages incurred from being removed from possession. A tenant could also sue to regain the unit. The law is very clear on this point. Relatedly, if the landlord denies the tenant access to some portion of the rented space, say, an allotted parking space, that, too, constitutes a breach of the covenant of quiet enjoyment. The tenant subject to such a partial eviction has the option to terminate the lease and sue for damages. But what if the landlord doesn't physically interfere with her tenant's occupancy? What if the landlord creates an environment that's so miserable that the tenant is forced to flee? Is this an eviction that would allow the tenant to consider the lease terminated? Or must the tenant stay and continue paying rent while he brings a damages lawsuit? Fidelity Mutual Life Insurance Company v. Kaminsky. 768S.W.2D 818, Tex. App. 1989. Murphy, Justice. The issue in this landlord-tenant case is whether sufficient evidence supports the jury's findings that the landlord and appellant, Fidelity Mutual Life Insurance Company, Fidelity, constructively evicted the tenant, Robert P. Kaminsky, M.D., P.A. Dr. Chapter 8, Leasing Real Property 269. Kaminsky, by breaching the express covenant of quiet enjoyment contained in the parties' lease. We affirm. Dr. Kaminsky is a gynecologist whose practice includes performing elective abortions. In May 1983, he executed a lease contract for the rental of approximately 2,861 square feet in the Red Oak Atrium building for a 2-year term which began on 1 June 1983. The terms of the lease required Dr. Kaminsky to use the rented space solely as an office for the practice of medicine. Fidelity owns the building and hires local companies to manage it. At some time during the lease term, Shelter Commercial Properties, Shelter, replaced the Horn Company as managing agents. Fidelity has not disputed either management company's capacity to act as its agent. The parties agree that, 1. They executed a valid lease agreement, 2. Paragraph 35 of the lease contains an express covenant of quiet enjoyment conditioned on Dr. Kaminsky's paying rent when due, as he did through November 1984. Dr. Kaminsky abandoned the leased premises on or about 3 December 1984 and refused to pay additional rent. Anti-abortion protesters began picketing at the building in June of 1984 and repeated and increased their demonstrations outside and inside the building until Dr. Kaminsky abandoned the premises. When Fidelity sued for the balance due under the lease contract following Dr. Kaminsky's abandonment of the premises, he claimed that Fidelity constructively evicted him by breaching paragraph 35 of the lease. Fidelity apparently conceded during trial that sufficient proof of the constructive eviction of Dr. Kaminsky would relieve him of his contractual liability for any remaining rent payments. Accordingly, he assumed the burden of proof and the sole issue submitted to the jury was whether Fidelity breached paragraph 35 of the lease, which reads as follows. Quiet enjoyment. Lessee, on paying the said rent, and any additional rental, shall and may peaceably and quietly have, hold and enjoy the leased premises for the said term. A constructive eviction occurs when the tenant leaves the leased premises due to conduct by the landlord which materially interferes with the tenant's beneficial use of property. 270. The premises. See Downtown Realty, Inc. v. 509 Tremont Building, 748 S.W.2D 309, 313. Tex.App. Houston, 14th Dist. 1988, NWH. Texas law relieves the tenant of contractual liability for any remaining rentals due under the lease if he can establish a constructive eviction by the landlord. In order to prevail on his claim that Fidelity constructively evicted him and thereby relieved him of his rent obligation, Dr. Kaminsky had to show the following. 1. Fidelity intended that he no longer enjoy the premises, which intent the trier of fact could infer from the circumstances. 2. Fidelity, or those acting for Fidelity or with its permission, committed a material act or omission which substantially interfered with use and enjoyment of the premises for their leased purpose, here in office for the practice of medicine. 3. Fidelity's act or omission permanently deprived Dr. Kaminsky of the use and enjoyment of the premises, and 4. Dr. Kaminsky abandoned the premises within a reasonable period of time after the act or omission. For example, Downtown Realty, Inc., 748 S.W.2D at 311.